everyone, and thank you for joining us for another session of Coffee Chat, Thompson Hine's weekly web series on matters related to the financial services industries. Today is Wednesday, October 20th. I'm Sineneng, the Senior Managing Associate in Thompson Hine's Investment Management Practice Group in Columbus, Ohio. In addition to advising investment companies and investment advisors, I also have over 15 years experience litigating business disputes, including the defense of derivative shareholder lawsuits. And that brings us to today's topic, recent trends in shareholder litigation. Joining me for this half hour are two experts in the field and co-chairs of the firm's Securities and Shareholder Litigation Group. In New York, Thompson Hine partner Renee Zaytsev focuses her practice on the representation of corporations, directors, and officers in connection with alleged violations of the federal securities laws and alleged breaches of fiduciary duty. Renee also advises corporations and board of directors on corporate governance matters, shareholder activist situations, and proxy contests. And in Cleveland, Thompson Hine partner Tom Ritzert focuses his practice on complex business litigation and dispute resolution, and has significant experience defending corporations and directors in class and derivative shareholder actions challenging mergers, acquisitions, and tender offers. Good morning, and thank you for joining me today, Tom and Renee.
Good morning, Philip.
Just a quick reminder to our viewers before we get chatting and you take another sip of coffee. If you have any questions or comments during today's program, please join the discussion by using the Q&A box on your control panel. We will address your comments as we move through our discussion. If we don't get to your question, please accept our apologies and know that we will follow up with you after the program. So, Tom and Renee, the headlines from the past 18 months have been dominated by the ongoing pandemic, as it has quickly become the defining event of a post-9/11 generation. The full impact and lasting effects of the pandemic on how we conduct business remains a developing story. But one development that we know is, as a result of the pandemic, companies whose operations stalled became particularly vulnerable to takeovers and interventions by hedge fund activists. Well, to kind of throw it off like these acquisitions and takeovers, corporations have quickly used the poison pill. The poison pill being developed in the 1980s to fend off such acquisitions has kind of evolved over the past, 3 decades now. Poison pills generally work by diluting a stockholder who acquires more than a certain percentage by allowing other stockholders to purchase shares at a discount. Since their development in the 1980s, they've evolved. They've been used in response to specific activist threats. They've been used to protect net operating loss carryforwards. And recently, in the past year, we've seen a new variant of poison pills with low trigger thresholds that have come under scrutiny. One such poison pill being the poison pill adopted by the Williams companies. And that one came, Renee, under particular scrutiny by the Delaware Court of Chancery for being particularly aggressive. Can you describe for us some of the features of that pill?
Sure. So what was interesting about the Williams pill, there are a number of different factors. So the first thing is that the Williams pill represented a little bit of an evolution in the purpose of these poison pills. As you mentioned, they were originally developed in the 80s to fend off corporate raiders and hostile takeovers. And since then, they have been used to defend against specific activist threats. And there's a category of pills that also helps companies protect their net operating loss carryforwards. And what was interesting about the Williams pill is that there was no specific activist threat there. It was a company that whose stock price declined in the wake of the pandemic, and also another situation that was going on with the Saudi Arabia oil war. And the company enacted the pill for the purpose of protecting against the generalized fear that an activist or a collection of activists might acquire a large block of the company's shares. And would not have to disclose that for 10 days after acquiring such a large block, given the 10-day window under the federal securities reporting regime that after you cross the 5% threshold. So that was an interesting evolution in that it was the first time really that a pill had been enacted without a specific threat. And then what was also interesting about it is that it had a number of unique features. First of all, it had a 5% trigger, which outside the context of protecting against protecting net operating loss carryforwards, it was one of only a handful of pills that had ever had a trigger that low. And so the Delaware Chancery Court did not look upon that particularly favorably. And there was also another aspect of it that said, and this is a pretty common feature of pills, where the pill will say when two people are acting in concert with one another. These are generally called wolf pack provisions, because most things in the corporate world have fun names. That those people's holdings will be aggregated. And what's interesting is that most of the time those wolf pack provisions go beyond the definition of group in the federal securities laws, and they'll be broader than just an express agreement to work together. But this pill went really far, according to the Delaware Chancery Court. And what it said essentially was that two people could be acting in concert together if they are both acting in concert with the same third party. And so conceivably, you could have two people that didn't even know each other existed that would be deemed to be acting in concert with one another. And the court found that that was a little too far. And then the last feature that the court really didn't look favorably on was the very, very narrow definition of passive investor, which again was narrower than the definition in the federal securities laws, and at least in this particular instance would have really excluded almost all of the company's stockholders, including BlackRock.
So you kind of touched on it a little bit, Renee, but maybe I could push just a little further. You've told us why the court didn't like it. It was there were hypothetical versions of short-term agendas. Stockholder activism was kind of a vague threat. You know, the Wolfpack provision was particularly problematic. What was the other reasons for the court to invalidate the pill?
You know, it was really the combination of all three of those factors that the court found was not a reasonable response to the threat that was identified. And I should say that the court didn't even find that the threat itself was necessarily sufficient. Because again, as I mentioned, typically these are enacted as defensive mechanisms against specific activist campaigns. And in this case, there wasn't one. And the court said the generalized threat of activism isn't really enough. But it assumed, without deciding for purposes of its analysis, that this, this sort of gap filling measure where the company wanted to make sure that there was not an accumulation of shares within that 10-day reporting window, that would be enough. And again, it just assumed that for purposes of the analysis, and then said, given that identified threat, it didn't think that the combination of this low trigger, this broad acting in concert provision, the very narrow passive investor definition, that was a reasonable response to the threat.
Well, what is a more reasonable trigger? And do we know, or are there, did the court say?
Well, if you look statistically at the pills that have been adopted outside of the NOL context, they typically have triggers that are at least 10%.
Now, you mentioned the fun names of Wolfpack provisions. I noticed that the daisy chain feature was also cited as a problem in the Williams provision. Is the daisy chain just another variation of the Wolfpack provision? Is it the same concept?
The daisy chain concept was what I described, where the court said you could have two people that are working in concert with the same third party and therefore be connected. That's what the court described as the daisy chain concept.
Got it. So what's now the outlook on poison pill litigation? Where do we go?
Well, what's interesting about it is that this decision that the court issued invalidating the Williams pill is actually up on appeal. And it was just argued recently. So if the Delaware Supreme Court upholds the pill, I think what we'll see is a lot more companies finding that there are reasons to adopt a poison pill, even absent a specific threat of shareholder activism, because of some either market as a whole situation or some company specific event that's going on. And so I think we'll see more of those pills adopted if the Delaware Supreme Court reverses. That's a big if. You know, we don't know what the Delaware Supreme Court's going to do. So that will be interesting to see what happens with that appeal.
I note that in the mutual fund world, shareholder activism has particularly taken rise. There is one hedge fund shop that has been amassing stakes in mutual fund board mutual funds and kind of trying to direct the course of management, and sought to influence a variety of goals, whether it be liquidation, termination of advisory agreements, election of new trustees. And so shareholder activism is certainly on the rise. And the poison pill may be one defense tactic to thwart off against those bids and takeovers.
Right, activism certainly isn't going anywhere.
Yeah, that's for sure. You know, Renee, one interesting thing, I'm sorry, Philip, before we move on.
No, go ahead,
just
please.
The concept about the Williams pill being that it was something that was undertaken when the board was in more of a clear day scenario. They weren't in a crisis scenario. They were more objectively thinking about pills and what they could enact. I'm just curious that it's interesting that you have a situation where the board was maybe having a more objective thought process, or at least more objective context to enacting the pill than if they were facing a real threat where some entrenchment concerns may come into play. So I think that's an interesting concept from this as well, that would be interesting to look at moving forward once the appeal plays out.
It is certainly really interesting, and one of the arguments that the company has raised on appeal is that because the pill was adopted on a clear day and not in response to a specific threat and not for any entrenchment purpose, that the business judgment rule should apply. And the reason that the court didn't apply the business judgment rule in the first instance is because of it said, look, all pills are just inherently entrenching. And so that's an interesting question for the Supreme Court to tackle on the appeal.
Yeah.
Well, thank you. And I just like to turn to our next kind of trend in shareholder litigation, and that's the surge in SPAC activity. And as we all know, where there's activity, litigation is sure to follow. So the stay-at-home orders and lockdowns that were imposed during the first few months of the pandemic caused disruptions to the IPO process, and special purpose acquisition companies, or SPACs, were not only seen as a viable alternative, but were a very popular route to taking companies public. SPACs pool funds in order to finance a merger or acquisition within a set time frame. If that acquisition is completed within the designated time, a de-SPACing transaction takes place and the newly merged company is listed on an exchange. And if it doesn't close within the time frame, investors can get their money back. The increasing popularity in SPACs led to speculation that SPAC litigation would soon follow, and those predictions have now come true. In just the first half of 2021, there were twice the number of federal SPAC class action filings than there were in the entirety of 2020. From what I've seen, most of them have contained claims alleging untrue statements, misleading statements, or omissions regarding material facts connected to the purchase or sale of securities. And it's this guiding principle or belief, rather, that financial interests of the SPAC sponsors are at odds with retail investors' interests, and that those sponsors are incentivized to complete business combinations, sometimes at the cost of conducting a thorough and adequate due diligence to protect investors. So Tom, maybe I'll throw to you. What do you see as giving the rise to this surge in SPAC litigation?
Sure, thanks, Philip. Well, I think obviously there's an increased number of SPAC transactions. And with the increased number of transactions and the media spotlight on SPACs, in 2020 the SEC issued some guidance that has served as a roadmap for plaintiff lawyers going forward about things to watch out for with SPACs as they consider what's known as de-SPAC transactions, when the SPAC actually finds a business that it wants to acquire and effectively take public. And a lot of the themes that you see focused on in these complaints mirror what you would see in some other shareholder litigation, but specifically the SEC guidance focused on that there should be adequate disclosures that clearly describe any conflicts of interest that may be involved in the transactions, that clearly describe the financial interests of the SPAC sponsors, directors and officers, and financial advisors, and consider whether the SPAC may pursue affiliated targets. And so I think that some of these guidelines have provided things for plaintiffs' attorneys to focus on when they're dissecting transactions, and you see that playing out in the content of the complaints that have been filed. And then there's also just this general concern that it's sort of new to the industry, this idea that you have what the chairman of the SEC had referred to as blank check IPOs. It's just a relatively new phenomena, and it's something that's going to be explored through litigation for sure.
Well, could you characterize a little bit more the nature of these lawsuits? Are they following the SEC guidance, or are there other kind of characteristics where you see that they are either following the roadmap, are they departing from the roadmap and adding claims that the SEC did not necessarily set forth? Sure.
So I think you can look at the types of litigation involved as sort of two stages of the SPAC's life. You have the pre and post de-SPAC situations. I think that from the initial part of it, when the SPAC is set up, that has not been as much of a target of litigation as the de-SPAC scenario, where you're looking at what the SPAC actually did with the money, what they decided to pursue. And I think that's where you're seeing a lot of similarities to what typical shareholder litigation has involved in recent years, certainly post the Trulia decision in the Chancery Court in Delaware, where it's, the concept of disclosure-only settlements have been more difficult to pursue in Delaware. I think what we've seen is a lot of complaints that have been filed in New York State Court alleging inadequate disclosures, breaches of fiduciary duty, and other torts. And many of those complaints have followed the typical trajectory you might see in other public transaction challenges of curative disclosures along with a mootness fee. And so that's definitely something that is more in the wheelhouse of traditional shareholder litigation. I think that some new dynamics that are coming into play in the context of SPACs are, one, an open question as to what standard of review is going to be applied in reviewing what the board did. There's also some inherent potential conflicts of interest in SPACs where you have the directors of the board of directors that have founders shares, and they have basically just a set value for their shares that they're going to get regardless of what happens. And also the whole concept of the model of a SPAC is, which they get investments and they have a set period of time in which to pursue a transaction and affect a de-SPAC transaction. I think that creates some concerns as to whether there are incentives just to find any transaction within the timeline so that they can complete the initial purpose of the SPAC. It raises questions about whether due diligence may have been short-circuited in the review of potential transactions. And so these are things that I think you're going to see play out as litigation unfolds. I think that at a high level, we're very much at the early stages of SPAC litigation. Most of these cases have been settled. There haven't been very many decisions that have been issued. And so I think it's going to be something that we're following over the next few years to come as to where the courts ultimately come out on some of these issues. And as long as they're not playing out in Delaware, if they keep playing out predominantly in New York, it may be some time before we get Delaware courts opining on such issues as the standard of review that applies.
Well, there is one interesting case pending in Delaware right now that alleges that the very nature of a SPAC is inherently laden with conflicts, and so a higher standard of review should apply. So we'll probably get a decision on that in the next, I think that was just argued last month, so we'll probably get a decision in the next 2 months.
The multi-plan case. Yeah, that would be interesting.
Well, Tom, it's interesting to me that, as you highlighted, all the various issues that arise with SPACs, the adequacy of due diligence, the adequacy of disclosures, yet at the same time, most of the lawsuits thus far have been settled. What's driving that? Do you have any idea or thoughts on? And you had mentioned mootness fees too. What's driving these lawsuits to settle so quickly without delving into the issues and getting a court opinion?
You know, my sense there, having not been party to any of those litigations, I just say that my sense is that that generally follows the track of most general shareholder challenges to transactions that you've seen recently. There typically is a path early on in those lawsuits that are not filed in Delaware to have some allegedly curative disclosures provided, and that allows the litigation to come to a conclusion, and it gives certainty to the people that are moving on with the post-transaction entities and the board that approved it. So I think that that's sort of not necessarily unique to SPACs. That's just something that's typical of shareholder litigation in general right now, that there still is a trend of disclosure-only settlements followed by what originally was some official award of attorney's fees, but now has become more of a mootness fee type procedure. And again, that's just another reason why these are predominantly playing outside of Delaware.
You mentioned how the standard of review for boards will become the new area of focus, or a potential new area of focus. What are some of the takeaways for boards, or what can boards do to kind of set up a defense or prepare themselves for a potential lawsuit or litigation?
Well, I think you may see some of the boards for SPACs start using the special committees. I've seen some publications about that advertising, suggesting that boards may want to contemplate using special committees. I think there will be definitely an emphasis on full disclosure of any interest of the directors, and including the financial advisors, whether they have some contingent payment arrangement, which gives them a kicker or some other financial incentive to get through any transaction. And so I think that the focus will be on full disclosure of what the interests and conflict of interests may be. And also there are already built into Delaware case law some procedures for the use of special committees, which help provide protection for the board of directors and also help ensure a lower, not necessarily lower, but at least a more desired level of review from the courts for the board of directors.
And diligence is also key, because there was an interesting enforcement action earlier this year with a SPAC called Stable Road, which merged with a space exploration company. And in that situation, the SEC brought an enforcement action and actually did not allege that the SPAC itself deliberately misled stockholders. It said the target misled the SPAC, but that SEC nevertheless brought an enforcement action against the SPAC because it said you should have done your due diligence, and the fact that you're coming up to the end of your 2-year or whatever that it happened to be in that case period where you have to do a deal doesn't give you license to ignore your due diligence obligations. And so that was an interesting enforcement action. The SPAC ended up agreeing to pay $8 million to resolve it. But the takeaway there is that diligence is key, and that is high on the list of the SEC's enforcement priorities as well.
And 2 years goes by quickly, and diligence is a long road, right?
Mm-hmm. Certainly.
There's also been in the news recently with SPACs, the question of whether SPACs are investment companies under the 1940 Act.
Mm-hmm.
And I note unique kind of coming together of national law firms to take a stand on this position. So let me just kind of set it up. There was a derivative lawsuit filed against Pershing Square Tontine Holdings in August, alleging that SPACs were operating or should be compliant with the Investment Advisors Act, because they were investment advisors and they had failed to register as such. and those that lawsuit got the support of a former SEC commissioner and a Yale law professor, and was getting all sorts of press. And like I said, over 55 national law firms have actually taken a position and signed a statement that SPACs are not investment companies under the 1940 Act. Tom, Renee, do you have any insight or any thoughts on this issue and on this new wrinkle?
Yeah, no, it's definitely interesting. I don't know that I've ever seen such an effort by a number of firms to come out so strongly against the concept early on in the process of these issues playing out in the courts. But yeah, you're right. I believe the last count was 55 or maybe just over 55 law firms that have signed on to this concept. And ultimately, the notion is that SPACs are just not their purpose is not really to invest, reinvest, or trade in securities. It's they don't view them as falling within the rubric of the 1940 Act, and certainly the nature of that, the rationale of those bulletins seems sound to me. I know, Renee, you've looked at those as well and had some thoughts on that.
I think it's now more than 60 law firms, actually.
Wow.
I mean, yeah, it's a lot of law firms. I mean, look, it gathered a lot of attention because the SPAC involved was Bill Ackman's SPAC, which is one of the largest out there. I think it was $4 billion or something like that. And the reality is, if I don't think that the argument has any legs, but in the event that a SPAC was deemed to be an investment company, I mean, let's be honest, that's the end of the SPAC era.
Right. And if I could just characterize it, it seems to be the position is that SPAC's primary purpose is not to invest, reinvest, or trade in securities, but rather it's to effect a merger, a capital stock exchange, or some other business combination. And so that's how they are distinguishing themselves.
Right.
It's always interesting, and when there's potential politics involved, and whether or not this lawsuit or various lawsuits similar are agenda driven. And so I guess we'll have to stay tuned, but it's nice to see law firms getting along for a change, right?
Yeah, right.
Well, thank you, Renee and Tom. We are off. Can you believe a half hour has we've already filled it up? So thanks so much for joining me this morning, taking time out of your very busy days, and providing us your insight.
Certainly happy to.
Thank you very much, Philip, and thank you everyone for joining.
Yep. Thank you for joining. Yes. Thank you.
Absolutely. Yes. And I reiterate, thank you to those of you watching. Thank you for joining us this morning. We hope you'll come back next Wednesday when Mark Miner will discuss strategies for responding to NASDAQ's board diversity rule. To rewatch this or any other previous Coffee Chat, please go to Thompson Hine's channel on YouTube or visit webinar recordings on the investment management page of our website at www.thompsonhine.com. As you sign off, please take a brief moment to take a survey on today's program. Until next time, take care, stay well.